Now officially opening the meeting of Panel A, the Medical Board of California. It's a small room, you could all hear me probably. I'm Dr. Ron Lewis, the chairman of Panel A, and I will be opening the meeting and asking for the call, a roll call to establish a quorum.
Here.
Here.
Present? Okay. Was the court reporter, do you have everybody's name, or do we need to? You are, I just want to make sure. Okay. Now I am going to turn this over to the ALJ, who will introduce herself and begin the meeting.
Good morning, everyone. We are on the record in the matter of the statement of issues against Andrew Nam Kai. This matter has been assigned Medical Board Case Number 800-2017-013865 and Office of Administrative Hearings Case Number 2019-010010. Today's date is January 31, 2019. My name is Jill Schlickman, and I am an administrative law judge with the Office of Administrative Hearings. Today, I have been assigned to preside over this proceeding. At this time, I will take the appearances for the record, starting with the Attorney General's office.
Good morning, Your Honor, members of the board. My name is David Carr from the Attorney General's office representing the complainant in this matter.
Thank you.
And Your Honor, my name is Dominique Polera. I represent Dr. Kai, and Dr. Kai is also present.
Good morning. All right. In making your presentation today, you should bear in mind that the board members have read your written argument and that the argument may be based only on the existing records. Ms. Pollara, you will be allowed 15 minutes for your argument. Mr. Carr will then have 15 minutes for complainant's argument, and each party will have 5 minutes for closing argument. After the hearing, the board will meet in closed session for deliberations. The board's decision will not be announced today. A written decision will be mailed to you as soon as possible. All right, and I understand that, Ms. Pollara, that your client intends to address the board this morning?
Yes, Your Honor.
Okay, so I think before we get started with argument, I'm going to put him under oath. Okay, so would you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that your testimony in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, and would you just state your name for the record for us? Thank you. Okay. Did either party want me to let them know when they have reached a certain point in their 15-minute time period, or are you keeping track of that on your own?
Your Honor, I do have a little bit of a timer here, but if you could let me know when I reach 8 minutes.
8 minutes, okay.
That would be great.
Anything?
I have a watch. Thank you, Your Honor.
All right, perfect. Okay. And I understand, Ms. Pollara, that you are going to begin the argument today.
I am, Your Honor.
Okay. All right, go ahead.
Thank you very much. Good morning, Your Honor, members of the board. My name is Dominique Polera, and I'm here representing Dr. Andrew Kai this morning. I have a little bit of a cold, so please excuse me if I am a little bit hoarse or cough. I'll try not to do that. I know you have read the briefs, and we are here today because the board has had the wisdom to non-adopt Judge King's proposed decision in this case concerning the denial of Dr. Kai's application for his California medical license. There are two issues that I want to focus on here this morning, if I may. Number one has to do with the application that Dr. Kai submitted to the board. Dr. Kai has never disputed that he answered question 31 on his application incorrectly. He answered that question no when he should have answered that question yes. He has never disputed that he made a mistake in doing so. He interpreted the question too narrowly, and that was wrong. He testified about that at the hearing as to how he interpreted the question, and that information is available for you in the record. The second point, and I think the more central point to why we're here today, is the position that complainant has taken that Dr. Kai is not qualified to have a license here in California because he lacks truthfulness and integrity as a licensee. There is no question that honesty and integrity are essential characteristics to being a licensee in this state, and any state for that matter. It's central to being a physician. What the complainant wants you to believe in this instance is that the error that Dr. Kai made on his application is essentially the tip of the iceberg, that Dr. Kai is a serial liar, that he's a teller of untruths in a consistent manner, and because of that, he does not meet the qualifications to be granted a license by the board. In doing so, the complainant argues that the board should conclude that he's not being honest and he doesn't have integrity because he was found to be repeatedly untruthful in the course of his residency, because he answered the question 31 wrong and because he lied at the hearing. And I want to focus, I've already talked about the application, but I want to focus on what happened during his residency. There is no question that Dr. Kai's residency director accused Dr. Kai of lying. Dr. Kai testified at length at the hearing about the situation and what happened. He can answer any questions you might have about that today, but it's unrefuted, it's undisputed in the testimony that he was threatened with immediate termination if he did not admit to lying. Now, the complainant argues that this is disingenuous and uncorroborated. What I would submit to you is that this argument is entirely unfair. The complainant had the ability to call Dr. Fuller at the time of the hearing so that Dr. Kai could confront this witness against him. This did not happen. That is a cornerstone of due process in our state, that people have the right to confront witnesses that are testifying against them. And in fact, these hearsay allegations by Dr. Fuller were simply that, and number two, they were never proven to be accurate in any hearing or in any proceeding that occurred during his residency. At no point during his residency was Dr. Kai given an opportunity to refute these allegations that he was untruthful or to clear the record. So that right was not afforded to him in his residency. There's nothing in the record, board members, that indicates that he was actually found to have been dishonest during his residency. And the bottom line is that the testimony about these threats against him are unrefuted. What we do know is that Dr. Fuller's behavior towards Dr. Kai was so unusual that the chief medical officer and vice president of Cooper intervened. That was Dr. Cooper Smith. He testified at the hearing at length and specifically testified that Dr. Fuller's reaction to Dr. Kai was unusual and difficult to navigate. Even the board's expert, Dr. Silva, had to concede at the hearing that there was some question about whether Dr. Kai was being treated fairly in his residency. The complainant attempts to bootstrap the claim that Dr. Kai was repeatedly found to be untruthful by making certain references to the record. However, again, none of those individuals were called at the hearing, and when you actually look at the statements that are in the file, none of those witnesses specifically said that they thought, in fact, Dr. Kai was being untruthful. Dr. Kislyak said, "At times I am not sure if he's being truthful or if he has presented the story in its entirety to his senior." I would submit that that is not a statement that he was being untruthful, and that is an unfounded allegation without any basis. Dr. Kim, similarly, did not come out and state that Dr. Kai was being untruthful, and Dr. Caputo, the other reference by complainant in the brief, does not state that Dr. Kai was being untruthful. It says, I caught him cutting and pasting, which is one of my pet peeves, especially when the information is false. Now, the physicians here on the panel are well aware of issues with medical records and problems with cutting and pasting. It is something that goes into learning how to create a good medical record. So perhaps Dr. Kai was not appropriately documenting a medical record, and by cutting and pasting something that was inaccurate, was perpetuating that inaccuracy in the record. That is something that happens on occasion. It's not something that we like, and that's part of the learning process. But that doesn't mean that Dr. Kai was being untruthful or that he was intending to deceive anyone. You have to ask yourself, if Dr. Kai had been found by his residency to be repeatedly untruthful, would the chief medical officer, Dr. Coopersmith, go to bat for him, write a letter, testify for him at the hearing? Would Dr. Lawrence Miller, the chairman of the Department of Orthopedics, go to bat for him, write a strong letter in support of them? In fact, neither of them would, ladies and gentlemen. Lastly, before I turn this over to Dr. Kai for his comments to you, I would submit that if you actually look at the testimony at the hearing, that Dr. Kai was not being untruthful or changing his story at the hearing. He was attempting to explain the situation using—
And you are at 8 minutes.
Thank you. Using his retrospective thoughts as to what had occurred during a very challenging and difficult point in his life. And so now I will turn it over to Dr. Kai to address you. Thank you.
Good morning. I'm Andrew Kai. I want to first thank you for giving me the opportunity to speak to you today. This is a very important situation for me. This medical license is very important to me, and I appreciate your time listening to this discussion. I also acknowledge and understand that patient safety and having physicians with the utmost character and integrity is very important. It's a top priority of yours, and I want to reassure you that it's also a top priority of mine. With that being said, I want to take full responsibility for everything that's happened to this point. I realize that ultimately it's my career and it was my decisions and behavior that has brought me to this position. It's been a long 3 years where I've done a lot of self-reflection, and by realizing my shortcomings, I was able to grow as a person and as a doctor and improve myself as a doctor worthy enough to take care of your patients, I believe. With that being said, I want to touch upon 3 things. First of all, I want to share with you the shortcomings I realized I had in my residency program moving forward. I want to share with you what I've done to improve myself and build upon those. And as well, I want to share with you what having a medical license in California means to me. So with my shortcomings, I think the most pressing issue here and concern with the medical board is my integrity and my character. I want to emphasize to you that I did not ever become untruthful or was untruthful in my residency program. However, I did concede to being untruthful, and I realized that was wrong. What I should have done was stick firm to my beliefs and stand up for myself, but I didn't do that. And by failing to do so, I disrespected myself. I also want to talk about question 31. I do realize and I take responsibility for answering it incorrectly. However, I want to stress to the medical board that I did not intend to deceive when answering incorrectly. However, I realized that I should have done my due diligence in making sure I understood the question, and I should have been more proactive and asked you specifically, what do you mean by any limitations or restrictions, special requirements placed on me? I did not do that. That was my fault. I take responsibility for that, and I'm sorry. Had I known, I would have understood the question correctly, and I would have answered it in the affirmative yes. I realized that these two examples, as well as many other examples, was a pattern in my residency program, and that pattern stems from my inability to communicate correctly. And I realized I had a deficit in my communication skills. I also had a submissive attitude in my residency program, which also was a detriment to my communication. I realized that I wasn't being prepared for my residency program. I didn't establish realistic expectations at home. In addition, I wasn't able to cope well with my other stressors in life. For instance, my father's illness and being in a very stressful situation in a high-pressure residency program. It's my fault for not being able to do that, and I take responsibility for that. I understand how all of these shortcomings could lead people to have a negative impression of me and perspective of me. And I understand how that would affect their behavior towards me. And it was my responsibility to be able to address these shortcomings earlier, and I didn't. So I take full responsibility for that. Moving forward, I've grown so much from this experience and learned so much. I realized I have communication issues, so I took a business communication class. And what I realized from that class is that I have a certain communication personality that differs from other people and also is similar to other people. But it differed, I believe it differed with my program director, with his personality of communicating. And it was my failure to adjust my communication personality to match his, so he would understand when I was trying to speak with him about any problems that arose. And it was my failure to adjust that. I also realized that, I have to understand who I'm speaking to and be able to adjust, and I've learned that. I've also realized, I talked about being submissive, having a submissive communication style, which is very unhealthy, meaning I kept my head down. When conflicts arose, I tried to avoid conflict instead of solving it. I didn't stick up for myself when I believe I should have. I chose the rights of other people and the preferences of other people over mine when I shouldn't have. And I knew that was wrong. What I should have done was have an assertive communication style where I do speak up for myself. And I'm not afraid of confronting conflicts, so then I could make sure I clarify any misconceptions or misperceptions about me.
And you have 1 minute left.
Okay. So after that, I established better realistic expectations at home with my wife. She fully supports me. She understands the rigors of my residency program and fully supports me. And I've become empowered as a doctor overall by having a higher standard to take care of patients. I continue my orthopedic surgery studies since I left my residency program in 2017. I am inspired to go into academic medicine because of the errors I made and the growth I've made as a doctor. And in closing, this California medical license means a lot to me because my wife is from California, her job requires her to be here, and I want to be here to support her as well while doing my orthopedic training. It's also important to me to protect my integrity and character overall for having this medical license, and I worked very hard to be here. Again, I take full responsibility for everything I've done. I've grown as a doctor. I hope that you see me worthy to have a medical license so then I can fulfill my lifelong purpose in healing people to make them healthy so then they can be healthy to fulfill their life purposes. Thank you.
Thank you very much. Okay, Mr. Carr.
Thank you, Your Honor. In the board's assessment of whether the denial of applicant's license was proper and grounded in fact, we only need to go as far as a careful and full reading of the proposed decision by the experienced law judge who had the opportunity to hear Dr. Kai testify under oath, not only in a presentation as he's offered you today, but under cross-examination by both myself and the administrative law judge, who found after that full and careful assessment that he was repeatedly untruthful in his representations, both documented instances in his residency program, which, despite his attorney's representations today, did afford him the opportunity to refute those allegations in a written statement, which is part of the record. that he was found to be disingenuous in his responses in a self-serving fashion on more than one occasion by more than one individual, and that his portrayal of the program director as being on a personal vendetta against him, which is the sole basis for the residency program's findings of deficiencies, is an unmerited assertion that is again refuted by the findings of the administrative law judge after the full and fair evidentiary hearing at which applicant testified and his character witness testified as well. Would note that those character witnesses, Dr. Coopersmith primarily among them, were not in the position of the program director and were not in a position to understand and have access to all of the relevant facts that Dr. Fuller put into his assessment over time, repeated assessments when there was a performance improvement plan, an action plan instated in order to help Dr. Kai move forward toward success in his residency program. When he failed to do so, and when he continued to compound the problem by misrepresenting facts that are crucial to the determination by the program director, those instances were documented. And those, again, are part of the record, and they are only part of what the ALJ found, the administrative law judge found, to be a pattern of dishonesty, which creates a tremendous concern going forward, not just for what happened in his residency program, but what the board must consider today in deciding whether to uphold the denial of his license. Dr. Kai was found, as I said, to be misrepresenting essential facts in his residency program on more than one occasion by more than one reporter, and that's documented within the record. Again, he has acknowledged today that he answered question 31, a crucial question about whether any probation or special limitations have been placed upon him during his residency program. He falsely answered that no. He would have you believe that is simply an error of interpretation, but without much surprise, it was an error that adduced to his benefit. It was self-serving in his denial. Again, in his explanation, a written explanation to the board about that false averment on his application, he told one version of events that differed from what he had told his residency program about the failure to satisfy requirements that his program director had placed upon him. When he came to court to avail himself of the opportunity to present a full and clear and candid admission of what had happened and an explanation to the board of what had happened, he changed his story yet again, and that is documented within the administrative law judge findings. His statements were unpersuasive because they were untruthful. It goes to a very fundamental question of professional, personal, and clinical judgment when a person who has been alleged to have been untruthful is given the opportunity under oath to be candid and disclosing and forthcoming, and instead creates yet a new version of the events that now continues to blame someone else, to claim never before version of events that includes coercion by the program director, that he reiterates today, that simply states that he is the victim of this personal vendetta, and that his only real failing throughout the course of these various processes is that he is insufficiently self-assertive, that he has been too deferential to others. I would contend that is not the kind of character flaw that a board would concern itself with, but his misrepresentations, his conscious, knowing misrepresentations, his false statements to the board on repeated occasions are a matter of very grave concern, and they warrant the denial of his license. As the administrative law judge noted, he has not taken responsibility, and he has not demonstrated competency, which includes that credibility in any competent practitioner, which is essential to safe practice. And that fundamental character quality is not a transient episode, but is more a continuing character of the person at question, and has been demonstrated by this applicant on repeated instances, even when he was given the opportunity to explain it. and fully make explanation that would satisfy the board about not only what had occurred and that it was a matter of past events, but that he was now being fully disclosing and taking responsibility for his actions. He has yet failed to do so, and on that basis, I would suggest the board needs to endorse the findings of the administrative law judge, who found that he's not ready to be licensed in California and uphold the denial of his license based on that failure. Thank you.
Okay, thank you, Mr. Carr. All right, Ms. Pallara, you have 5 minutes.
Thank you very much, Your Honor. First of all, what I would say is that there is no dispute in this case that Dr. Kai had performance-related issues during his residency, and that there was a performance improvement plan that was put in place following an action plan to address those issues. I don't think that is in dispute. The fact, I think what I'm hearing from Mr. Carr is that Dr. Kai changed his story in front of the judge at the hearing. In fact, if you look at the Exhibit D that was admitted into evidence at that time, which was a complaint to Human Resources by Dr. Kai during his residency, it underscores and supports what he testified to at the hearing regarding the problems that he was having with the program director. I would urge you to conclude that Dr. Kai's application for a license should be granted so that he can complete his training and become a productive member of the California medical community. It would have been easier, ladies and gentlemen, for him not to come and go through this today. It is not pleasant for him to sit here and listen to Mr. Carr and the statements that he's making, these embarrassing allegations that he's an untruthful person. He's tried to be introspective and to explain what went into the events that occurred during his residency. There's no question that he should have done things differently. Sometimes those realizations come as the result of going through a very difficult situation. He should have stood up for himself. He should have sought advice before he answered the question. He should have sought advice from other senior people during his residency to deal with that very difficult situation. I would note that, if someone has a character for dishonesty, it just doesn't spring up at a certain point in time. This is a young man that went through college. He got a master's degree. He went through medical school. There was never any implication before he entered his residency program that he was untruthful or that there was any issue at all regarding his integrity. And I don't think there's any dispute about that. There's no question that his first year of training was complicated for many reasons. He did not quit. He did not give up, even in the face of being ostracized by his residency director and the senior resident. He has an opportunity to continue his training. He was offered a position at UC Davis as a junior consultant so that he could continue under the supervision of the chairman of orthopedics at UC Davis. He needs a license in order for him to do that. And I would urge you to give him that opportunity, to allow him to prove to you that he, in fact, can be a competent, caring, compassionate physician here in the state of California. So thank you.
Thank you. Okay, Mr. Carr, your closing remarks.
Thank you, Your Honor. Dr. Kai has had an opportunity to present evidence to this board to persuade us, both in his application, in his residency program information and results, in the evidentiary hearing that we had in which he presented evidence and was represented by a different attorney, and at which he testified, and which we have the consequent results documented in a detailed and thorough proposed decision, supporting the denial of his license and before you today, but I would suggest, members of the board, that giving Dr. Kai a license to practice is not a means of affording him an opportunity to demonstrate what he should have already demonstrated for the board to its satisfaction. There should not be a trial period, even if he's operating under a structured environment under the auspices of other practitioners who are competent and knowledgeable in attending, that opportunity was afforded him on repeated basis, and he failed to make the most of it because he continued to misrepresent essential facts. Coming here today and asking for another opportunity with a full license to practice is an inappropriate request, and giving him that license would be an inappropriate means of testing whether he is to be in the future trusted with such responsibilities. Based on that concern, I would urge the board to maintain the denial of his application for licensure, and with that, I will submit as well.
All right, thank you. Okay, we'll turn to board member questions. Dr. Lewis, did you have any questions for the parties?
Yes, yes, I do, Your Honor. I have a question for Dr. Kai. I'm trying to read in the report anything about your relationships with other colleagues, residents in the program, because it really talks about Dr. Fuller, Dr. Coopersmith, and more senior level attendings.
Mm-hmm.
So can you explain your other relationships with your
Sure.
fellow residents?
Sure. I would say that my relationship with other residents I didn't have much of a relationship with my other residents because I was always keeping myself busy with my work, and I didn't really seek out their guidance or mentorship in order to really like understand how to be a better resident. I would say that for most part, I think in every residency program, I'm sure you can attest to that, is that there's different personalities, and I try to get along with all the personalities as much as I could, as much as I knew how to. I would say that the residents there overall are very supportive of other residents. They try to look out for you as much as they can. We were a new residency program, trying to find our way and being able to be as much help as possible to everyone else. And again, I do have personal feelings about certain relationship with residents, but we are professionals here, and we have to learn how to get along with everyone. And that is something that I've been working on since that residency program.
Thank you. I know that when I was a resident centuries ago, we would get to understand our teachers through other residents at third-year level, fourth-year level, whatever.
Mm-hmm.
And it's kind of surprising to me that you didn't seek any help from the people just surrounding you, but that's the way you chose to do it. So that's that's the way it was. But
to clarify, they told me about instances where there were people criticizing me of my performance, and one specifically said, "I will be there to help you speak to the program director if need be." And unfortunately, I didn't take his help. I was very submissive. I was afraid of confrontation. I was hoping that if I just kept my head down and worked really hard, they would recognize me for my efforts. So when I mean that I never sought out their help, I never was proactive even when they told me about things that I had deficits in, that people were talking about.
So, let me interrupt you. You used the word twice now, submissive.
Correct.
But I'm not sure what you mean by submissive.
Mm-hmm.
Afraid to ask? Tell me
Yeah.
what you're talking about.
So
You
I learned
used it.
about in my class, and everything is that there's different types of communication styles. You have assertive, submissive, passive-aggressive, manipulative, aggressive. And the submissive style, most of them are unhealthy. The most healthy style is assertive. But a submissive style is where you don't really speak up. You don't speak up for yourself. I don't articulate my concerns. I choose the rights of others over my rights, even though I should be protecting my rights while respecting their rights. And it's like a very martyr-like behavior where, I don't confront people. And that was very prevalent in my residency program when I say submissive. Like, people were telling me that, Andrew, there's rumblings that you're having a hard time, and there's also people that are being very vocal about your errors that you're making, which I feel they said it's normal for an intern to make, but you should definitely address this, and I didn't because of my submissive style.
And one last question, maybe ALJ can answer this for me. In our report, I didn't see the HR reporter conclusion. Are we supposed to know what they concluded? Because you interviewed them, correct? HR?
HR, I basically emailed them.
Well,
Yeah.
I don't,
It's a Exhibit D that was admitted into evidence. There's an email and there are attachments to it.
And I
Okay.
believe the question is, was there a response?
Yeah.
Or the question, was there a response from HR to me?
Response.
There was no response from them. I had to call them myself, and at that point, there was no response from them.
Okay. Thank you very much for your answers.
all right. Mr. Wormuth, do you have any questions?
I guess the only thing that I would ask is, it appears to me that things sort of started going off the rails when you were assigned some modules.
Correct.
Could you describe your understanding of what you were assigned and your understanding of, I guess, the differences between the written and the video
Okay.
documentation?
You're asking me my understanding of the modules. My initial
And I'm also asking you what your understanding of what you were supposed to do.
what I was supposed to do. Okay. So my initial understanding of the learning modules was to do the reading assignments. And I understood there were videos associated. However, I thought the reading assignments were the primary goal, and the videos were either a supplemental to it. So that was my initial understanding. And that was a wrong understanding, because what I was supposed to do and understand was that I was supposed to do both, the videos as well as the readings. And I understood it after speaking to my residency program director after that meeting.
All right. Dr. Hawkins, did you have any questions?
Yes, thank you very much. Thank you, everyone. So, Dr. Kai, just like for you to reiterate for the panel, this is a statement by your counsel. What was that narrow interpretation that allowed you to answer question 31 the way you did?
Absolutely.
What was that narrow
Absolutely.
interpretation?
My question 31 asked me if I had any limitations or special requirements placed on me during my residency program. And my narrow interpretation of that was that they were regarding to patient care, duties regarding patient care. And that was my interpretation, and I knew that was wrong. It was a very narrow interpretation. I understand that in the performance improvement plan, it did say that I would have a limited scope with patient care, but the reality, it wasn't. It wasn't true. In fact, I had a higher work volume while being under this PIP, and my duties didn't restrict in any way. I did every duty I did before the PIP, and I continued to do it afterwards. Now, with that being said, as I mentioned earlier today, I should have been more proactive about understanding the scope of that question. My initial scope was that it was about patient care, which I believed it was. I did not have limitations on patient care. But now, after reading the transcript, what Mr. Carr said, going back to the trial, even then, during the trial, I still had a narrow scope of what that was. I still thought it meant patient care. And if you go back to the transcript, you'll see my confusion when answering Mr. Carr's questions. It's after I read that transcript, and I reflected more about it, and I took this business course, and I realized the errors that I had, that I realized that question was a broader scope. It was regarding It was regarding seeing an employee assistance program officer as well as seeing a learning specialist. And now I understand that those are also considered special requirements. And that's why I'm telling you that I recognize that I answered it wrong and I should have answered it yes.
Last question is, similar to Dr. Lewis, I'm still in private practice, and medicine is collaborative, particularly if you're going to do the best for the patient. None of us know all that we need to know, and none of us know enough if we don't talk to our patients, listen to our patients. So you think you're going to pursue an academic orthopedic program. I just wonder, in this business course, which I may not be able to ask about, I'm not really sure, how are you going to make an adjustment to the practice of medicine? I mean, are you going to actually, if given the opportunity, take care of patients? How will your personality be different if you're given an opportunity to practice medicine in the state of California? I'm sure that the practice of medicine involves working with colleagues. There's no question about that. If you're going to do the best, be the best type of doctor you can be. And our patients do deserve that. So if you can give us a little bit of a feeling for that.
Sure. I've had a lot of growth from this experience, and I've grown in many different ways. The business communication course has taught me how to become a better communicator with my colleagues. That means being able to understand their questions, being able to answer it appropriately, figuring out exactly what they're speaking to me about, and being able to answer appropriately back to them, closing the loop with the communications. And it really gave me a better sense of who I was as a communicator and what I needed to do to make sure that I effectively communicated with them. By communicating effectively with my coworkers in the healthcare industry, I would be able to give better care for my patients. Because you understand that this is a complex system where multiple departments are involved in the care of one patient, and communication is key for that. I learned actually that from my residency program. In my residency program, I learned that I need to communicate better by closing the loop with people. So when I speak to my team about our plan, I have to make sure that I close the loop with everyone else that's involved with their care, other departments. I realized that you can't really communicate well with notes, because even if you write notes, sometimes that message doesn't get transferred over to the other departments and teams. So I've learned to actually physically see every team and call them every time our plans have changed and I need to communicate something. When I order tests and labs, I realize that I can't just order it in the computer. I have to call and make sure that I follow up with them, that they see that there's a lab there. There's a lot of nuances of being in a hospital as a resident that requires communication. And I learned that through my experiences in my program. Besides being a better communicator, I also continue to study how to take care of my patients. And that means being able to properly assess them, manage them, being able to communicate with other teams to give them the appropriate management, and appropriately discharging when it was correct with the appropriate follow-up. Those are things that I learned in my internship, and I continue to learn when I become a resident. I'm inspired to go into academic medicine because I learned through all of my errors of what it requires a resident to have to be successful. And one of those things I've learned is that in order for residents to be successful, they need to have good mentorship, they need to have great leadership, they need to be able to be confident and assertive with their communication. And I fell into a lot of pitfalls in those regards, in all of those categories. But because of that, I learned from it and I grew, and I see the value. I see the value in all those things, and I see how important they are for residents to grow so they can be nurtured to be great doctors. So that's why I want to go into academic medicine, because in addition to taking care of my patients, I want to help nourish residents so they can be good doctors too.
All right. Ms. Wright, did you have any questions?
I apologize to my panel members because it's probably going to be redundant, but I'm admittedly struggling a little bit with your response to why you responded the way you did to question 31. Is that better? Okay, I apologize. I just said that I'm admittedly struggling with your response
Sure.
to why you responded to question 31
Mhm.
the way you did, which sounds less of a communication thing to me and more of a comprehension thing. And I don't mean that in an insulting way. I'm being very sincere. So is the reason you didn't ask for help about clarity about question 31 relate to your submissive personality and you not wanting to seek help?
Mhm.
Because I'm a little lost
Sure.
about this. And did you, when you were filling out the application, was there nobody in your residency program that could help answer the question? Because I'm maybe even getting lost in translation.
Sure.
Maybe we're having a
Yeah,
communication disconnect. 'Cause I'm
Right.
struggling a little
I
bit.
understand where you're coming from. I understand your confusion with my answers, and hopefully I can clarify with you. So my submissive attitude back then, and you're right, comprehension is part of communication. Being able to comprehend something, if you can't comprehend it correctly, that is a communication error. So I did have comprehension issues as well as a submissive style, which basically led me to misunderstand the question and not comprehend it correctly. Yes, so I hope I'm answering your question clearly. I didn't ask anyone in my residency program for help on this application. I do attribute it to my submissive style back then. I should have. Sure. You know, to be frank with you, I was still scared in my program. I was still scared, and I didn't confront anyone. I was afraid of talking to my program director directly about anything.
Practice of medicine seems to me to be about a lot of people interaction.
Yeah.
And I can say that sometimes I'm not the most pleasant patient.
Mm-hmm.
So have you gotten over the embarrassment, and are you able to now confront things head on or seek help?
Yeah.
Like if somebody comes into your office and they need help,
Mm-hmm.
or you're dealing with a difficult colleague, are you going to be submissive and then there's going to
Mhm.
be problems and you're back before us again? Or are you going to be able to handle that?
Mm. So if I'm understanding your question correctly, there's two facets to that question. One is how do I handle my communications with my patients, and two is how do I handle my communications with my colleagues. Actually, with my patients, I am very proud of my communication. I think the way I handle my communication with my patients is on a different level. I pride in my compassion with them, and I understand where they're coming from. I've had a very interesting and unique background with my family, and my mother having her disease, HIV, and seeing how much medicine helped her. You know, we came from a very humble background from the ground up, so when I speak to patients, I am locked with them. I'm on the same page with them in terms of what they're worried, what their concerns are, and how I can help them, you know. And ultimately, it is the patient's authority of what they want to do and where they want to go with their healthcare. And what my job is to be is an advisor for them and a guider to help them do what they want to do with their lives. So with patient care, I am confident, I can confidently say that I communicate very well with them. With my colleagues, on the other hand, back then, I did not communicate very well with them, but I've learned to be better by being more assertive. And that means whenever any kind of conflicts arise, I automatically jump to make sure that they're resolved. And that requires better communication. That requires me understanding what the conflict is, what their concerns are, and after acknowledging it, giving them what my perspective was, and then finding a common ground and a middle ground to solve whatever problem there is. So, you know, when I move forward, moving with colleagues, I am going to be more assertive, and I'm not going to be submissive. Respectfully, I'm going to be assertive. And I know that will serve me well when we figure out the best management for our patients to give them the best care.
If you understand the diagnosis, you'll be able to go somewhere and get a comprehension of what that means.
Exactly.
All right, Dr. Yip?
Thank you. My fellow member addressed most of the question. One last question is, and I think you have a lot of good answers that I hear today. One question I see is that part of the problem, the stress in your life at that time, your father, you drive 7 hours back and forth. Now I assume East Coast, you're in California, newly wed, maybe a baby coming up, a new job. Are you doing anything to do that so that you don't go back to the same position you were in?
If I understand your question correctly, you're asking if I have made adjustments in my personal life to make sure that I can succeed with the rigors of my training moving forward as being a doctor.
More the way that how do you make yourself to be able to stand up to stress?
Right. Right. So how do I deal with stress better?
Professional life in medicine is
Right.
actually going to be more stressful,
Mhm.
not just being in residency,
Mhm.
practice and academic. Are you able to train yourself or to do something, class, etc.? What is the plan you're
Right.
making?
So from my experience, stress builds when you have more priorities and things pulling you in different directions. In order to manage that better, I have to manage expectations better at home. So what I've done is me and my wife, we've had a very long discussion about this. As well, for the last 3 years, we've been tested in every angle that you can think about in terms of our strength for each other. And we've came to an understanding of the rigors of being a doctor, how much sacrifice it takes and how much time it takes from me in order to become a doctor and be a good doctor, and we're on board with that. And she fully supports me with my career. That was something that I did not address when I first started my residency, but I did address it now, and we're on the same page moving forward. My father is better now. He had lymphoma cancer. He was cured. So at the moment, he's better. Another part of dealing with stress is communicating your stress to your mentors and your colleagues. Not to make an excuse, but just to give them a better understanding of where you're coming from, so then maybe they can work with me to find a better way to get better. And I'm going to do that moving forward. I've learned with, especially Dr. Coopersmith and Dr. Miller, how to open up, you know? Because when I was there, I was very submissive, and I didn't open up. I felt that, you know, both my parents are immigrants, and, you know, they taught me what they knew, and that is being an honest person, working hard, and working hard and not making excuses. And I thought not opening up and talking to my colleagues and my mentors about my stresses at home was making an excuse. And that's the reason why I never brought it up. But I realized it's not an excuse. It's actually detrimental. It's just sharing my perspective so that we can find a solution. So moving forward, if I ever have any stressors like that, I will be very open with my communication about them so that we can find a way to get better. And I've done that ever since opening up to Dr. Coopersmith and Dr. Miller, and it's been working well. So.
All right, thank you. I don't see any other questions, so at this time we will close the hearing. We're off the record.
Well, let me make the one announcement. Our panel member, Ms. Brenda Sutton-Mills, has now joined us on the panel. So that will be in the record. And for Diane to put on the roll call that she is here. Thank you.
Good morning. We are on the record in the matter of the in the matter of the accusation against Long Day Liu, MD. This matter has been assigned Medical Board Case Number 800-2014-009126 and Office of Administrative Hearings Case Number 2019-010012. Today's date is January 31, 2019. My name is Jill Schlickman. I am an administrative law judge with the Office of Administrative Hearings, and today I have been assigned to preside over this proceeding. At this time, I will take appearances for the record, starting with the Attorney General's office.
Good morning, Your Honor, members of the board. My name is David Carr of the Attorney General's office, representing complainant in this matter.
Thank you.
Good morning, Your Honor. I'm Steve Zeigen, representing Dr. Liu.
Thank you. And Dr. Liu is present as well. Good morning. Okay, in making your presentation, you should bear in mind that the board members have read your written argument and that the argument may be based only on the existing records. Dr. Liu and Mr. Zeigen, you will be allowed 15 minutes for your opening argument, and Mr. Carr will then have 15 minutes for complainant's opening argument. Each party will have 5 minutes for closing argument. After the hearing, the board will meet in closed session for deliberations. The board's decision will not be announced today. A written decision will be mailed to you as soon as possible. And I understand, Mr. Zeigen, that Dr. Liu will be addressing the board today, so I'm going to ask you, Dr. Liu, if you would raise your right hand to be sworn. Do you solemnly swear or affirm under penalty of perjury that your testimony in this proceeding will be the truth, the whole truth, and nothing but the truth? Thank you. Since we do have our court reporter here, she's trying to take everything down very accurately. When Dr. Liu speaks, I'd like you to turn the microphone over to him, okay?
Yes, Your Honor.
All right, and I understand, Mr. Zeigen, that Dr. Liu will address the board during the final 5-minute period of your argument. Is that right?
That's correct.
Okay. Did either party wish for me to alert you at a certain number of minutes during the argument, or are you able to keep track of your time?
I would appreciate a 5-minute warning.
5-minute warning. You've
Thank
got
you.
it. Okay. All right. Let me just get my... Okay. Go ahead, Mr. Zeigen.
Thank you. As much as it pains me, panel members, I have to begin my presentation with an admission that I misread the notice of non-adoption. I read the 4th paragraph in which it said, should the discipline be modified, when in fact the 1st paragraph said, should the discipline be modified to protect the public. That is my error. However, it does not change the substance nor the conclusion of what I'm about to say today. Before discussing what I believe to be the utter lack of evidence to support a number of the conclusions reached by the administrative law judge, I want to point out that there is not one citation to the record in the Attorney General's brief with respect to the statement of facts. While it's indicated there are stipulated facts, those facts do not in and of themselves support the allegations of the accusation. As I go through my argument, it may be tedious, but I'm going to ask the panel members to bear with me because I will cite specific areas in the testimony which specifically undercut the conclusions reached by the administrative law judge. With that being said, I'm going to start with patient LN. I'm going to use initials given the sensitivity of the matters. There are 3 time frames with respect to patient LN, and at this point in time, I am going to assume, as the judge said, that the panel members have read the record. The first time frame is between the postpartum hemorrhage, which was first encountered, and the time Dr. Liu left the hospital at 12:52. The one thing that's crucial, and the one thing the administrative law judge missed, and did the Deputy Attorney General who did the hearing, Dr. Greenberg, the board's expert, was in no position to render a valid opinion. Why is that? Because contrary to the production of discovery, as is in the record at April 10th transcript, that's April 10, 2018, at pages 109, 112 to 114, and 146 to 148, Dr. Greenberg had never seen the declaration of Dr. Wang, which was our Exhibit F, had never been shown the exhibit of the anesthesiologist, Dr. Cow, which is our Exhibit E, had never read the testimony of the trial transcript of the ICU attending nurse, Ms. Nguyen, Nguyen, which was Exhibit A, and obviously had not heard the testimony percipient of Dr. Wang nor of Dr. Liu. I do not believe, therefore, she was in a credible position, despite what the judge said, constantly characterizing her testimony as credible, to render a credible decision as to the patient's stability at the time Dr. Liu left the hospital. In addition, the record shows that Dr. Greenberg had the wrong vital signs. She looked at the wrong part of the record when talking about the vital signs of the patient, ignoring the fact that the patient, although a bit tachycardic, had a stable blood pressure of 100/60, was talkative, was not bleeding, and according to Dr. Wang, who was the chief of surgery at Garden Grove at one period of time, and the assisting surgeon with Dr. Liu, it would not have been appropriate to perform a hysterectomy prior to the time Dr. Liu left the hospital. So I ask you, particularly you panel members who are doctors, how Dr. Greenberg could reach a credible decision when she was not aware of the most crucial evidence, not evidence from stipulated facts from the accusation, not evidence from Dr. Greenberg's uninformed opinion, but the evidence of 4 percipient witnesses to the condition of patient LN at the time Dr. Liu left the hospital. Nor is there any truth to the judge's conclusion or the accusation that Dr. Liu failed to consider coagulopathy. How do we know that? I'm sure the doctors who are panel members are aware of the medical term DIC. Dr. Liu not only tested for DIC prior to the time he left, the test coming back normal, he ordered the test be redone after he left in case something occurred, and as the record shows, inexplicably, without informing Dr. Liu, the test was canceled. The DIC test, when you say DIC, the C stands for coagulopathy. So for the judge to say in her decision at page 11, paragraph 59, that Dr. Liu did not consider coagulopathy is specifically belied by the evidence. The evidence which shows he ordered the test is at RT February 20, page 84. The test was ordered at 11:19 and came back prior to the time he left. It was normal. In addition, the judge's decision to find that Dr. Greenberg, who she always asserted testified credibly, and that's her word, that Dr. Liu failed to comply with ACOG, is belied by the very testimony which Dr. Greenberg did not see because it was not provided to her by the Deputy Attorney General doing the hearing, even though she testified after Dr. Wang, that Dr. Wang specifically told the court that Dr. Liu comported not only with hospital protocols, but ACOG protocols. He also stated that when Dr. Liu replaced the Bakri balloon prior to his leaving because it fell out, a hysterectomy was not required. It was not warranted. The ALJ heard this evidence, panel members, but either forgot it or inappropriately ignored it. Page 12, pages 12 to 13, paragraphs 63 and 67 of the ALJ's decision says Dr. Greenberg testified credibly, there's that term again, that Dr. Liu had no direct contact with the physicians or the nursing staff of the ICU. This is patently wrong. RT, February 20th, 2018, pages 75 to 77. Dr. Liu spoke directly with the ICU nurse, while Dr. Cao, the anesthesiologist, was in direct contact with Dr. Hakim, the intensivist, who was not at the hospital. There was no confusion over who had the responsibility for the patient. Now, that takes us through the first time frame. The second time frame, panel members, is between 12:52, the time that Dr. Liu left, and 3:34 or 3:20 when he was finally contacted via the phone by Nurse Wynn, because the patient under her watch crumpled, crashed, and coded. And he, Dr. Liu, was not contacted till the code. He got back to the hospital in 14 minutes. So the period from the time he left the hospital till the time he got back, the accusation and the AG both acknowledge, can't fault Dr. Liu for anything during those approximately 3 hours. Takes us to the third time frame. And again, it's almost as if the judge heard what she wanted to hear. The third time frame, after Dr. Liu returned at 3:34, Dr. Greenberg, during her direct, initially faulted Dr. Liu for not taking the patient immediately back for a hysterectomy. But hearings, as the attorney members of the panel know, have both direct and cross-examination. And the purpose of cross-examination is to undercut, perhaps, the testimony on direct. And that's exactly what happened. At RT, I'm give you number of sites, April 10th, 2018, pages 194 to 195, 199, lines 7 to 13, 200, lines 13 to 29. Under cross-examination by Mr. Rosenberg, Dr. Greenberg said this was a nightmare patient, the kind of patient no doctor wants. She acknowledged that a reasonable anesthesiologist would not have cleared the patient upon his return at 3:34 in the morning. And later, she also said that, I already mentioned that it was a nightmare. I also want to refer you to the testimony of Dr. Taraction, who agreed that no reasonable anesthesiologist would have cleared this patient for surgery at that time. That is RT 423, April 23, 2018, pages 95 to 96 and 98 to 100.
And you have 5 minutes left.
Oh my goodness, okay. Nor is there any truth to the conclusion that Dr. Liu failed to change his practices. The judge is the only one who asked the question, and as counsel on the panel know, you can't prove an accusation if the AG doesn't ask questions. The questions the judge asks are at 220:18, pages 95 to 96. Dr. Liu did say he changed his practice. He also showed a number of CME certificates which showed he attended high-risk obstetrical conferences, did a whole number of things in order to become a better physician, which the judge absolutely ignored in her decision. Interestingly, the definition of clear and convincing and gross negligence are not referenced in the AG's brief. Gross negligence has been said to be the want of even scant care. Given the Herculean efforts by Dr. Liu in this matter, that's clearly not the case. And clear and convincing evidence requires there be the reasonable assent of every reasonable mind with regards to the conclusion desired to be reached. With respect to the other patients, I just wanted to point out that the consent issue was the most baffling of all, because even Dr. Greenberg admitted there were a number of hospital consent forms, and Dr. Taraction said this is exactly what you're supposed to do, but somehow Dr. Greenberg found the consent still inadequate. With respect to the other repeated acts of negligence, Dr. Liu testified he now does the GB test at 35 to 37 weeks, so that's been remedied, and he's been doing that since 2015. With regards to the glucose monitoring, Dr. Taraction testified why there was in fact glucose monitoring, and with respect lastly to the position of the fetal head, Dr. Liu testified that because she was fully dilated, which was not accurately alleged in the accusation, he actually could determine the position of the fetal head. So if anything, and the only thing, it was a matter of documentation, and since the hearing, he has completed the PACE records keeping course, again, in an attempt to try to become a better physician. Thank you, Your Honor.
All right, thank you. Mr. Carr.
Thank you very much, Your Honor. Members of the board, attorney for Dr. Liu would today like to retry this matter without the awkward impediment of producing admissible evidence or being cross-examined, thank you, sorry, on that evidence or his own testimony. That is inappropriate and wholly unnecessary for the board's determination today. The administrative law judge who heard this matter laboriously sets out clearly and in detail in 112 paragraphs of factual findings the numerous departures from the standard of care, both extreme and simple repeated acts of negligence, as to 4 patients in Dr. Liu's care and treatment of those patients, which were, again, serious departures from the standard of care. Counsel's characterization
of the ALJ's descriptions of Dr. Greenberg's, the board's expert in this matter, as being repeatedly found to be credible is no criticism. That is a ringing endorsement of the fundamental need to have a witness on whom you can trust and believe, especially in matters of expert testimony. Here, the only question before the board, the only important matter to be determined in this proceeding is whether the penalty that would appropriately flow from these detailed and accurate findings is appropriate. I would suggest it is not, and the board properly held this matter for a careful review, which is being done at this point. In the administrative law judge's proposed decision, she finds that the specific conditions and terms of probation would be adequate over a 5-year period to ensure safe and competent practice by Dr. Liu. However, in the actual order, there are no specific terms and conditions imposed. I would suggest that this was an inadvertence, an omission, which happens to everyone in the course of their professional career, I know, to include those specific and necessary terms and conditions. Instead, the only conditions imposed are the general conditions of probation. There are no measures, steps taken toward clinical remediation of Dr. Liu's practice or to ensure that safe practice other than the terms of notification, obey all laws, quarterly declarations, general requirements. Again, nothing that specifically addresses the clinical needs of remediation and careful scrutiny of his ongoing care under probation. If this order is modified to necessarily include appropriate remedial measures, such as successful completion of the clinical education program at PACE or an equivalent as appropriate, the specific educational requirements of an education course, additional CME, addressing the clinical deficiencies identified in the proposed decision, and most essentially, a practice monitor to be appointed and approved who would be able to oversee and adequately monitor Dr. Liu's practice to ensure that safe level of practice that allows the board to have the confidence that he should be allowed to continue to practice. These are the changes that will make this proposed decision an appropriate resolution in this matter based on all of the, again, detailed and comprehensive findings by this experienced law judge who finds actually 13 departures as to these 4 patients and identifies specific areas of concern, and yet in the proposed decision there is the inadvertent omission of specific conditions to address those omissions. That can be rectified by the board. The decision could then be adopted as modified, and the board would have reasonable, effective assurance that Dr. Liu will be monitored and overseen in his practice, ensuring to the extent that we can that he will be practicing safely. On that, I would submit. Thank you, Your Honor.
All right, thank you very much. Okay, Mr. Zagan, you have 5 additional minutes.
Thank you, Your Honor. I'm struck by the fact that while eloquent, Mr. Carr was nowhere near the hearing. I would venture to say, without having facts to support it, that he hasn't read the record, that what he's doing is regurgitating in a very eloquent fashion the substance of the brief. But within his argument, there's the inherent contradiction, and I hope you guys picked it up. This experienced, well-intentioned, well-versed judge inadvertently left out every condition to underline the probation. I submit to you that rather than leaving it out inadvertently, it was an attempt by the judge to say, I want the medical board to take care of this. I don't want the responsibility. You have to read the record, because if she was inadvertent when it came to doing the order, I submit it was as likely she was inadvertent in ignoring the various evidentiary points that I pointed out to each panel member with respect to each of the accusations that she sustained. The evidence contradicts virtually every conclusion she reached. And it's not a matter of balancing it 51 to 49. It's clear and convincing proof. When the board's expert does not have access and has not read the precipient declarations of those people who were there at the time of the incident involving patient LN, and when the board's expert backtracks on what she said with respect to the performing of the surgery, and when the board's expert ignores a half a dozen consent forms, and when the board's expert doesn't hear that Dr. Liu has now done the GB test at 35 weeks for the past 4 years, something is very, very wrong. And while I submit that the 5-year probation, let me rephrase it, I submit the 5-year probation under those circumstances when you review the record, and you must, is well in excess, almost bordering on draconian, that this gentleman sitting to my left did an absolutely wonderful job with all 4 patients, and other than documentation issues, which could result in support of PLR, does not deserve probation. I'll reserve whatever time I have left for Dr. Liu.
All right, 2.5 minutes. Go ahead, Dr. Liu.
At first, I will say, I'm a hard work about the patient LN. I did everything before I left to the hospital. Unfortunately, after I left hospital, 2.5 hours, the patient vital signs changed, and the nurse didn't call me until they called Blue. When I come back, the condition changed to worse, and that time is unable to do the bring her to the hospital room right away. So we did very hard to conserve treatment.
May I make a suggestion?
Yes.
The court reporter is having a very difficult time. That's okay. Dr. Liu has a written statement. I could either read it or have someone read it or just introduce it or show it to the AG after he's had a chance to try to express himself so that the record could be clear. Is that possible?
Is that okay with the board? Yeah.
Yeah.
All right. Do you want to read the statement?
Are you okay with that, Mr. Carr?
I am.
Okay. With Mr. Carr has indicated his approval. Are you okay with it, Your Honor?
If you would like to read the statement he's prepared, that's fine. And
Okay.
then we can follow up with questions of Dr. Liu if we have the board
Okay,
members have
thank
some
you.
questions.
I really appreciate that. As you know, having read the record, we at times did use an interpreter. Sometimes it was me, but I've listened to him long enough. Okay, here we go. This is the statement. I want to thank the panel for giving me this opportunity to address them. First, let me say I am heartbroken over what happened to patient LN. I tried everything in power to save her. When I left the hospital, she was in stable condition. I did everything in accordance with ACOG guidelines to get her to that point. Had I been called by the hospital prior to her coding, I quite possibly could have saved her. But when I was finally called and returned to the hospital, she was so unstable on my arrival, I could not take her to surgery. Even the board's expert, Dr. Greenberg, admitted this. After this event, I attended a conference on high-risk pregnancies to see if there was anything else I could or should have done. I also now insist on speaking with the charge nurse personally prior to leaving, although that was never a necessity prior to LN. As for patient PW, I did fully advise her and her husband about the possibility of vacuum-assisted delivery. I did treat her PPH, that's postpartum hemorrhage, according to ACOG guidelines, and both mother and child were discharged in good condition. As for patients KB and XJ, I did give the group B strep tests early, but always gave them prophylactic antibiotics at the time of admission. I now do all such tests at the recommended 35 to 37 weeks. I have completed the PACE record-keeping course in an attempt at improving my documentation. Panel members, I am a good, competent OBGYN who just got recertified for another year in November 2018. I pose no danger to the patient population. Again, thank you for listening to me.
All right. Dr. Liu, is that your statement? Yes. Okay. Okay. Then at this time,
Okay.
oh, I'm sorry, you have one
Yeah.
thing to
All
add?
the 4 patients was under standard practice. Yeah, I tried to do everything I could. I do the best I have.
Thank you.
Thank you.
All right. Mr. Carr, your closing remarks?
Thank you very much, Your Honor. The implications by counsel that the ALJ, if indeed she was knowledgeable, experienced, and attentive, would not have omitted the paragraphs or the cut and paste or the macro paragraphs of specific terms and conditions that would have been available to her, ignores the common pitfalls and problems of word processing, given our current fashionability and processes. And this simple omission is in no way an indictment of the administrative law judge's ability or attention to this case, and suggests instead, as I would have the board understand, an omission, which was a wholly inadvertent one, and does in no way discount the very clearly set out and documented findings made in the proposed decision. The implication that there is intentional wrongdoing by the trial Deputy Attorney General, by the expert Dr. Greenberg, or by this administrative law judge is a reprehensible suggestion that should be rejected outright, and in no way taints the evident effort made by all participants on the part of complainant to ensure a fair and full hearing and that a proper resolution be reached. I will conclude by quoting the findings of the administrative law judge, which she concludes that Dr. Greenberg, who was the expert you recall for complainant, provided credible and persuasive testimony solidly based upon specific references to the pertinent ACOG guidelines. She did not advocate for one side or the other. Rather, her answers were direct, honest, and thoughtful, without regard to whether or not they helped either party. That is the kind of impartial expertise we could all hope for in any kind of evidentiary hearing. It was procured, produced here to assist both complainant's case and to assist a full and fair fact finding in Dr. Liu's matter. It should be held to be the appropriate conclusions, and that the proposed decision is valid in all aspects, with the addition of the remedial measures that I suggested to the court, to the board, I'm sorry, that of clinical competence assessment program, PACE or its equivalent, an education course geared to the deficiencies identified in the proposed decision, and a practice monitor to ensure safe practice going forward. With that, the board could be reasonably assured of safe practice by Dr. Liu, and the findings will have been used substantially to further both Dr. Liu's practice and the board's mandate of public protection. Thank you.
Thank you. Okay, at this time, we will move to questions. Dr. Lewis, did you have any questions for either of the parties?
I have a question for Dr. Liu. Question for Dr. Liu. In your typical practice, what percentage of your patients are high risk versus normal OB patients?
Okay, and this 10%, most of the high risk pregnancy, I send it out to the UCI because I only take regular patient, OB patient.
Did you understand that?
Yes, he's, if I'm clear on this, you don't accept high-risk patients. They may become high-risk during your care?
Yes, but that time, according to the ACOG treatment, if really have too much trouble, I always send out to the high risk or OB like a UCI medical center. I try to take care of easy case.
Okay. Thank you.
Yes.
Thank you. Mr. Wormuth, did you have any questions?
No, I don't.
Okay. Dr. Hawkins?
I do not.
Thank you. And Ms. Seton-Wills?
I just have a couple of questions. If we're not to completely ignore the findings of the ALJ, the factual findings, and there were some discipline that were to be, or some correction that was to be in order for Dr. Liu, what would that be?
Are you directing it?
Yes, I am, Counsel.
It's you have to understand, Ms. Sutton-Willis, many of the gross negligence allegations were also alleged as repeated acts of negligence. It's our position that none of the gross negligence, because the only true gross negligence for patient PW was the consent issue, which I think I've adequately addressed, would be repeated acts of negligence. As Dr. Liu testified, he now does the tests appropriately at 35 to 37 weeks in accordance with guidelines. He has taken the PACE record-keeping course. He's followed up with other things to make him a safer doctor. And I know it's very difficult when we're dealing with the death of a patient. I understand that. But once the evidence is looked at in what I believe to be a reasonable fashion, if a determination of discipline is required, then a PLR, I believe, is adequate. Why? Because when you look at the testimony with respect to each of the witnesses, the deviations that were alleged and determined to have been proven were not. And as much as that disturbs Mr. Carr, the fact of the matter is I was at the hearing, the judge was at the hearing, and there's a record of the hearing. I've read the record. I'm trusting the panel to have read the record. So in direct response to your question, Ms. Sutton-Willis, I don't see anything other than a PLR being warranted under these circumstances.
I just have a follow-up question. I've heard a couple of references to attending a conference, but what specifically was offered at that conference, and was there some level of testing, or what do we mean when we say that he attended a conference on high-risk birth in order to cure this issue? Like, what actually was done there?
That is a wonderful question. Let me get my notes out, because they were also introduced as exhibits. So the panel can look at the exhibits to determine exactly what the conference is in the high-risk obstetrical area concerned.
That's something different. What they offered and what Dr. Liu actually undertook.
Yeah, I don't know the answer to that. I'll have to ask him, and hopefully we can get the answer.
Is that something that was in the record?
Yes. Well, the fact that he attended the conference, and I don't remember specifically. Well, let me go back to your question, Doctor. Ms. Sutton-Willis, sorry. There was in the record, and this is again something that the ALJ ignored. He was proctored. Dr. Liu was proctored, and actually the Deputy Attorney General during the hearing stipulated that every proctoring procedure, and that included C-sections, that included other more complicated obstetrical and gynecological procedures, he rated exceptional. And it's in the record, because one case was rated satisfactory, and the judge wound up questioning Dr. Liu about that. I don't have the specific site in my head. I think it may be in the brief. But that I can tell you, that with respect to his proctoring, he was already proven immediately after this incident. He went through, I believe it was 6 or 8 cases where the hospital proctored him and he received exceptional grades. Does that help?
Thank you.
Thank you.
All right. Ms. Wright, did you have any questions? Okay. Dr. Yip? Okay. All right. Then I think all of our questions are done, and we will close the hearing at this time. Thank you, everyone.
Thank you, Your Honor.
Thank you very much, Your Honor.
Thank you.